Good afternoon, ladies and gentlemen. Welcome to this afternoon session of the stakeholder engagement on the draft Kenya Civil Aviation Regulations 2021. As per our program, we have two sets of regulation to consider this afternoon. And we are going to consider the draft Civil Aviation Safety Management Regulations 2021. A short history of these regulations. They were first issued in 2015. Then we had 2018 set of safety management regulations. And these regulations are issued pursuant to the provisions of Annex 19 to the Chicago Convention. So to allow us go through these sets of regulations, I'll welcome my colleague, Ms. Lois Mwangi. Lois Mwangi is the State Safety Program Coordinator at the Kenya Civil Aviation Authority. And she'll go through the matrix of amendments of the regulation, as well as comments. I'd like to remind all of us that those who would like to make comments on these regulations, you can use the Ask Question option, which is on the right-hand side of your screens. And if you also would like to make an oral intervention, my apologies, ladies and gentlemen. I think we had an internet interruption. So as I was saying, the draft Civil Aviation Regulations 2021 on safety management are an amendment of the regulations issued in 2018, and they are developed pursuant to the provisions of Annex 19 to the Chicago Convention. So I'll allow my colleague, Ms. Lois Mwangi, the State Safety Program Coordinator, to present the matrix on amendments, then consider the written submissions that you had made. At the same time, we'll be considering the questions that you'll be posting in the Ask a Question box during the presentation. And then we'll allow dialogue where you can be able to get an opportunity to ask a question, clarification, or make comment. Like I said, these regulations, we would like to go through them, and then at the end of the session, we can ask questions. If you have any challenge regarding connections or any issues, please just drop your concern in the Ask a Question box, and we will be able to respond to it as we continue with the preparation of with the stakeholder engagement activities. So if we are able to, just 1 second before my colleague is able to make her presentation. Welcome, Lois.
Okay, thank you very much, Lawrence, for that introduction, I will share with you the proposed civil aviation safety management regulations. As introduced, these regulations are in alignment with Annex 19, and this is where we get our guidance and standards to develop these regulations. I will start with the amendments before I go to the comments that we have received. So these regulations, by the time they were being promulgated in 2018, we had the privilege of having incorporated the first amendment to Annex 19 that incorporated the 8 critical elements as part of the foundation of the state safety program, which was one of the critical changes in Annex 19. So the rest of the amendments have been minor and for clarity. We'll go through these amendments in the matrix. As seen by the amendments in regulation standby. When we look at the regulations definitions and interpretation, we had the definition of the safety oversight that had been amended to include the authority as the state, and that we have noticed that there was some inconsistency with the standard definition in Annex 19, so that was reworded, as you can see there highlighted, to include the state. The same it's the same with the second definition on surveillance, which had been reworded as the authority, but that has been reverted back to the state. Regulation 3 of the safety management regulations had an were read that there was an exemption that this regulation shall not apply to areas that include but not limited to occupational safety, environmental protection, customer service, or product quality. We felt that this was redundant because it is self-explanatory from the regulation that these are civil aviation safety management regulations in terms of operation of aircraft and in relation to aircraft operations. So that sentence was deleted. Regulation 4 talks about the establishment of the state safety program, and this was reworded for clarity, where we include the fact that this SSP shall be established commensurate with the size and complexity of the civil aviation system in Kenya. So that's just for wording and clarity. Moving to Regulation 7, this talks about safety assurance. As part of the SSP, the authority shall implement procedures and processes for state safety assurance in order to meet, and this also was rewarded for clarity, where we outline what the state is required to meet, and that is the surveillance obligations in accordance with the Regulation 4 and the safety performance measurements obligations. So that's also just for clarity. Same Regulation 7. This is just numbering and rewarding for clarity. And we jump to Regulation 9. Regulation 9 talks about the SMS and the applicability and the service providers who are required to implement an SMS. So in the initial regulations, we had talked about operators of aeroplanes or helicopters authorized to conduct international commercial air transport in accordance with the AOC regulations. So this was discussed in detail, and what came out is that as the authority, we have not yet established certification of commercial operators in terms of international or domestic operators, and therefore it is very difficult to only identify international commercial transport operators or the ones that are domestic only, so as to exempt them from the provision of the SMS. So this was discussed, and it was decided that we should remove the requirement for international commercial operations and have it that all AOC holders will establish an SMS. Regulation 9B is the same situation where there were international commercial operators in accordance with AOC and aeroplanes or helicopters engage in provision of training accordance with the ATO regulations. So this was deleted, the international was deleted. This is for AMOs because there's no clear definition of which AMOs only maintain international operations and which ones are maintaining operators of domestic operations. So this also, the international part was deleted. Remember, it might seem that we are being too punitive in terms of making sure that all AMOs and AOCs implement SMS, but SMS is established according to your size and complexity. So if you're a smaller AMO, your SMS shall be aligned with your size and not the other way around. Okay, so we go to Regulation 15. This is in safety data and safety information protection. And in terms of safety data and safety information protection, we added service providers as part of the requirement to provide this protection of safety data, so that it's not only an obligation of the authority, but also the service provider. And that will help us in collecting safety data and having that non-punitive approach where you know your data is protected. Regulation 15, number 3, also, we have added the requirement or the responsibility for service provider to protect information. So that's what has been added. That's in Regulation 15.3. Moving to 15.5, same thing, where we add the service provider to take the necessary measures, including the promotion of a positive safety culture to encourage safety reporting through the systems referred in Subregulation 11.2 and 3. So we agree that safety culture is a responsibility of both the authority and the service providers. Okay, we move to the second schedule where we talk about management commitment 1.1. This is just for clarity. Initially, the regulations talked about in accordance with international and national requirements. And this, we were informed that these regulations are part of the international and national requirements, so it was redundant to have that. And that's why it was rewarded to have it as the following requirements. And going into the schedule, 1.3, appointment of key safety personnel. This highlights the safety manager requirements, which were not defined in the earlier regulations in 2018. And we have received comments on this schedule 1.3.1, and all the comments that you have brought in have been taken into consideration. I will read through what has been harmonized across the board. As you all know, safety management, SMS is applicable or is supposed to be established by all the service providers. And therefore, we have harmonized with the AOC and the AMO regulations, including the ATO regulations. And we will have it as the requirements having a technically qualified person related to the product or service provided by the organization. That is basically in the field of aircraft maintenance, flight or ground operations, airport operations, air traffic control, and safety management. So for clarity, these technical qualifications that shall be considered is either a degree, a diploma, or a license. So there are those who are licensed, there are those who will have a degree, and those who will be considered if you have a diploma in your um, service, related product or service. Then the second qualification, have at least 5 years operational experience related to the product or service provided by the organization. Again, this is depending on your service. It could be maintenance, could be flight or ground operations, airport operations, air traffic control or safety management. And the third requirement, you must have successfully completed a professional training course in safety management system. And by professional training, what that has been there as a standard is a professional training. Most of the SMS courses take about 5 days. Then the last qualification that has been added, and just to give clarity, is successfully completed a management training or have at least 3 years of managerial experience. And this has been brought about by what we are seeing in the industry. We have seen safety managers that have been appointed that have no managerial experience, yet once you get to this position, you're required to be part of the management team and provide your management advice in terms of managing the safety of the organization. Okay, in the third schedule, on the principles for protection of safety data, safety information and related sources. This in the 2018, in the current, because they are still there, the 2018 regulations, the protection of safety data was put in the third schedule. And as a note, the protection of safety data has been deleted. These were guidelines that were there. And in terms of drafting, when it is a note, it is not really taken in as a provision. So these notes have been incorporated into the schedule, and you will see them as part of the provisions that are there for the protection of safety data. So these ones that have been deleted have already been put in as part of the provisions of the third schedule. Okay, so when we come to the general principle, same thing. In terms of, we have deleted the guidelines and added them as provisions of the schedule. If you look at the proposed text, you can see that clearly. So at 2.1, those provisions have been converted to the provisions as I had talked about. And that's what you have there, 2.1, 3.2. Okay, coming to note 4, in terms of principles of exemptions, there was a correction there in terms of the different authorities that may be designated for different circumstances. The competent authority could include, but is not limited to, judicial authorities or those otherwise entrusted with aviation responsibilities designated in accordance with national law. This was amended for clarity, which is to say the laws of Kenya. Because when you say national laws, it is very definite that we're in Kenya. So that was just for clarity and for drafting conformance. Then third schedule, number 5, in terms of public disclosure, this was also a clarification, because now we have the Data Protection Act. So B reads, public disclosure of relevant personal information included in the safety data or laws related to data protection, just to include that there are those laws of data protection and they come into force when we're talking about public disclosure. Okay. Number 7, this is the same thing in terms of note 1. The note was converted into a provision. So it reads that ambient workplace recordings required by laws of Kenya Kenya. For example, cockpit voice recorders or recordings of background communication and the oral environment at air traffic controller workstations may be perceived as constituting an invasion of privacy for operational personnel that other professions are not exposed to. So this note has been converted into a provision and is part of the protection of recorded data. So these types of data shall be afforded the protection and given this protection according to the exemptions and the third schedule as provided. Same thing on note 2. That note has been converted into a provision of these regulations. And also we have clarified at the bottom where we say provision on the protection of flight recorder recordings during normal operations are contained in civil aviation, AOC, and admin regulations. There was that reference to the operation of aircraft regulations, which were incorrect. That provision is in the AOC and admin regulations. So that was just for clarification. Same thing, protection of recorded data, deletion of guidance text, and that has been taken in as part of the provisions. And also at the end, 7.2, clarifying that these are the laws of Kenya, not just national laws. So that was for drafting conformance. And that's the end of the matrix, that safety management matrix. And I will go to the questions. Okay, there is a question here in terms of the years of experience. As we've said, we have harmonized with AOC and AMO, and the years that have come out is 5 years. So Wesley Kirui, yes, I said 5 years. Another question here, alignment. Yes, Elma, we have received that comment, and that has been aligned with the rest. Okay, we've had your comment on the font size. Apologies for that. Okay, you can hear us. Okay, okay, there's a question here. AMO regulations require that a safety manager at least 70 years. So as I've said, we have harmonized that. It will be across the board 5 years. So Lawrence, I think I haven't received any other questions. Maybe you can continue.
Okay, thanks, Lois. I've seen another question from one Wamshi Karanja. Wamshi Karanja is asking that we are talking about training management. Will there be specific guidelines issued by CAA describing course? Also, that there shall be uniformity in management courses, heads of safety present. If I get your question right, you're talking about the fact if KCAA would be able to give specific guidance on management training. I think my colleague Lois would tackle that. Rachel is talking about those minimum qualifications covered under AMO and AOC. AMO require 7 years. I think we've spoken to that. We've said that after your comments, we've harmonized, and we will be working with the harmonized requirement in terms of qualification. And that should be 5 years in terms of experience. So with regard to Karanja's question on training requirements in management, whether the CAA would be giving specific guidance on the course, and also that there shall be uniformity in management courses, head of safety present. Maybe Lois, you could consider that. But before you consider that, there is a question from Mike Kimunya. Say the title head of safety. Safety head is head of safety for AMO, AOC, ATO. in the SMS regulation, he or she is being referred to as safety manager. So we need to clarify that one also. So Lois.
Okay, thank you very much, Lawrence. I start with Mike's question. I had received this comment, and I think how to address it is that ICAO talks about a safety manager, and that is what we have taken in the safety management regulations. But having said that, head of safety, director of safety, safety manager, it's all the same thing. Yeah, going by Shakespeare's words, a rose by any other name is still a rose. So as long as you're doing those roles and responsibilities that are for a safety manager, whether you call the person a head of safety, safety director, chief safety, it's all the same. So it's about the roles and the responsibilities. When we talk about safety management, we talk about the outcomes and what you're doing. Going to Wamoshi's question, talking about management training. So safety management regulations are very performance based. We are looking at the outcomes. We do not prescribe for you what kind of management course you need to do. But in general, a management course has a minimum of 4 weeks training. I think that has already been given out from the Kenya School of Government, and all starting with a supervisory management training and executive management training. So this is either you have worked in management or you have that training. It could be either or. It doesn't have to be both of them. So it's either or. I hope that clarifies.
Good. Thank you, Lois. If anybody wants to be given the floor to ask the question, probably sometimes we lose the context of our questions in the text or the typing we do. Probably we could do that. I have a question I can see from Kamlesh Tang, and probably if Kamlesh, you are able to, if you are able to ask your question verbally, that would make it easier to understand the question. Are you able to ask your question verbally, Kamlesh?
Okay. Maybe I can address this other question as Kamlesh arranges himself to make a verbal comment. We have a question from Gad Kamau, Captain Gad Kamau. When he asks about the years of experience required for a safety manager, is it a standard or do respective CAs set that? As you well know, the authority also sets regulation based on the industry. So what we have seen in our inspections, in our audits, is that some of the regulated entities have not been appointing people who have the required experience. And we have set this as a minimum of 5 years will give you good experience to handle safety issues. So this has been discussed within the within the departments, and we have been informed that these people are available, and 5 years is a good enough point to even elevate someone to a management role of a safety manager as is required of that position. So it is not a standard, but it has been set by KCAA.
Thank you, Lois. We have 2 more questions. There's one from Atieno Onyango, or rather Anyango Otieno, talking about an engineering degree constitutes considerable syllabus coverage, covering safety, quality, and management over and above the maintenance training offered. Is such training considered as being applicable? Then we have a question from Woodron Wilson, which is SMS regulations requirement is hold or have held a license in any of the fields relevant to the organization. A more required degree, diploma, or license holder in aviation related field. Clarify. So those two questions would probably need to clarify.
Thank you very much, Anyango Tino, for your question. When you talk about an engineering degree covering safety, quality, and management, I believe that is on at a general perspective. When you attend a professional SMS training, it is tailor-made and it is specific to safety management system. So that will be considered as the professional training if you do one that is targeted to SMS and establishing an SMS in aviation. So the engineering degree will be considered as technical qualification. As I said before, there is a technical qualification that is required, either a degree or a diploma or a license, and then now there shall be the professional training course in SMS. So there are those two differences. There's a training for SMS, and then there's your technical qualifications that you have. Um,
Okay, I think that is clear. Kamlesh, you have the floor. You can
Hi, good afternoon.
ask your question.
Good afternoon, Lawrence. Good afternoon, Lois. I hope you can hear me.
afternoon. Yes, we can hear you loud and clear.
Yes, my concern, or it's not a concern, but it's just something that is there, which I also addressed earlier. This is the new training requirements as per the EKO Doc 10147. This is the guidance on the CBTA to dangerous goods training and assessment. And particularly over here, there's a relationship between this CBTA and safety management system. Has this been addressed in your in the regulations? Because as per 1.5 of the of the guidance that has been issued by ICAO, which was this year in 2021, there's been a mention of the implementing SMS requires that all personnel understand the safety philosophy, as described also in dangerous goods transportation. There's a lot of there's a mention of Doc 9859, which is the safety management manual. I believe that is one of the. It also falls under Annex 19. So I don't know whether this has been also incorporated with all the AMOs and the AOC holders, because it would fall under this criteria also.
Okay, thank you very much, Kamlesh, for that information. Not really a question. It's basically telling us more about this. What I know about SMS is that it is across the board. Whatever regulations we have for SMS will work for an AMO, an AOC, an aerodrome operator, an ATC. What you have described in terms of philosophy of dangerous goods aligning with SMS is something that shall be incorporated by the AOC holder as they implement dangerous goods safety reporting. On our side, what we have done is we have incorporated reporting of dangerous goods occurrences as part of our safety oversight. And we have allowed AOCs or even shippers to give us information on dangerous goods occurrences. So on our side, what we do is receive these occurrences, and then we do resolve the issues using our DGR inspectors. So the philosophy of safety is across the board, even with the introduction of dangerous goods. And this will be applied by the AOCs, and as the CAA is to take in these occurrences and resolve the issues that are raised. So that is our approach to your question.
Sorry,
Thank you, Lois. Kamlesh, I hope
yeah,
you've been satisfactorily answered.
before I finalize this, it's just that there's a recommendation that has been made by EKO that targets freight forwarders and ground handling agents to voluntarily implement SMSs, this SMS systems that you've mentioned. So I do not know whether that is going to also be incorporated into this new standards as on a voluntary basis.
Um, as you stated correctly, it's voluntary. As it is
Yes.
right now, we do receive those reports from the freight forwarders and the shippers. We do receive them. So it's voluntary, and with regulations, remember, is they're enforceable. So when it's on a voluntary basis, we desist from putting them in it as provisions in the regulations. So it could be part of our safety promotion and encouraging people to volunteer, but where you're not required by standards and by regulations to implement the SMS, we will leave it at that and leave it as a voluntary measure.
Okay, thank you very much, Lois. Thank you very much, Lawrence.
Okay, thank you, Kamlesh.
Thank you.
We have a question from Murugi Njama. She's asking about standardization of safety training for managers. We also have a question from Omar. Ali Omar. Ali Omar is saying that 5-year period is too long and 3 years is more practical. I think this is in terms of experience required for some of the positions. So, Lois, maybe you can take the two.
Okay, Ali Omar. This in issue was discussed at length, and it is well known that we have very qualified and people with experience in this aviation industry. Remember, a safety manager is someone who's taking a management role. They are meant to report directly to the accountable manager. So 3 years was seen as just below the line. So 5 years was good enough experience, and to have someone come on board as a manager and a safety manager at that, where you have the background experience of working in aviation and also giving the outcomes that are required in terms of conducting the risk assessments and coming up with the performance measurements. So if you have a strong conviction that 3 years is good, maybe we will need to discuss that more, but this is something that we have discussed even with some of our industry players. And 5 years came to be the bottom. We would have put it at 10 because we know they're there. The professionals are there, and we have people who have more than 10 years experience, and we are not limiting to current license holders. Even if you have held a license, you are eligible to be a safety manager. So that is the position we are taking, and we feel that 5 years is a good enough experience for you to be a manager. Murugi, your question on safety management training. As per ICAO requirements, as I said, safety management SAPs are very performance based. And that is why we do not want to be prescriptive and say that you should do course A, B, C, D. What we're saying, what are the capabilities? What are the knowledge, the skills, and the attitudes that you're required to have as a manager? And those are what we will be looking at. So when you come for your head of training interview, that is what we'll be looking at. You present to us a certificate that you've done a management course. Are you getting the knowledge, the skills, and the attitudes that are required for you to have that management position? So we are assisting and we are not going to be prescriptive in that nature. But as per ICAO requirements, if you even look at Doc 9859, they talk about capabilities of a safety manager. They don't even talk about qualifications. They talk about your capabilities. What can you do? So that is what we are also looking at and moving more into performance-based kind of regulation. There was a question about
Manuals.
changing the manuals. As I said, head of safety, director of safety, safety manager is all the same. There's no inspector in KCA that will tell you to change your manual because you've written head of safety and we are talking about safety manager. So it's one and the same thing. I assure you that.
Okay, thank you, Lois. So regarding the manuals, Hassan Ali, Huzaifa, and Flight Ops, you can be assured that the regulations will not necessitate an immediate change to your manual. So equivalency will be recognized, and there will be a transition period anyway, where probably in subsequent manuals, if you'd like to change, you'd change. So we have two people who would like to have the platform, the floor to speak. One is Captain Gad Kamau. I'll be asking Captain Gad Kamau to accept to speak, and then that will be followed by, he will be followed by Ali Omar. But Gad Kamau, you have the floor. Gad? Maybe as Gad Kamau prepares to come on. Okay, I can see him on. Okay. Captain Gad.
Can you hear me now?
Yes, you're audible.
Yes.
Okay, thank you very much. On that 3-5 years thing, aviation is very vibrant, and when we arrive at 5 years, you put a lot of pressure on operators, or even anything beyond 3 years, on operators to source out people that, and you know, these regulations, this cap ICAO 19 standards and recommended practices 19 is very recent. So when you talk about people being in the industry for the last 10 years, it doesn't mean that they are suitable. I am of the opinion that nobody in the industry was consulted, because being a member of the Kenya Association of Air Operators, at no point did we come across a member who said he had been consulted on that 3 to 5 years. It also is also a fact that most of the people drafting these regulations have not been in the industry for the last few years, and it is important that the industry is consulted. My contribution is that 5 years is too long. 5 years is too long to have someone be considered for that. 3 years is enough. And on another issue is the degree holders. We are rubbishing degree holders and putting them in a category of people who do not have experience elsewhere. Somebody with a degree, engineering degree, for instance, Nairobi University has put in 5 years of experience, and we don't seem to recognize that. Two issues. The industry should be consulted on the experience required for a safety manager. 3 years, I find that prime. That is enough for somebody to be considered as a safety manager. 5 years is a little bit on the high side. If there's somebody 10 years who is in the field, he might not have been involved in that particular field that you are looking for as a small operator. Can we consult with the industry more, please? Consult more with the industry, not have the regulator come to the field and walk around a few companies and then go back up to aviation house, lock themselves up and come up with numbers that do not serve the industry. Thank you very much for that opportunity.
It's okay. Thank you. We've had you, Gad. We'll respond to you after Ali Omar. Ali.
Good afternoon. Thank you for the opportunity. My 2 cents on the experience of 5 years, I believe it's too high. There's a lot of mechanisms in place with the regulator to ascertain competency, but competency cannot be ascertained by the number of years someone has worked. So 1 year is too little, 2 years is too little, 3 years I think is more practical. And this is, of course, subject to the interview process by the authority, where the authority may ask the candidate to demonstrate in the various questions and methods so that he can be determined to be competent. So I believe 3 years is best, but 5 years is too long. It puts a lot of pressure on operators. And sometimes you might not get the best candidate that the organization requires. So that's my 2 cents on it.
Thanks. I think we've heard from Captain Gad Kamau and Ali Omar regarding the experience in number of years. So in response to Captain Gad Kamau, yes, as you rightfully noted, we as the Civil Aviation Authority, we indicate the amount of years required for experience in our draft regulations. These were circulated, and the consideration was anywhere between 5 and 7 years. Written feedback from the industry, various players, is what led us to arrive at 5 years. And we have now received 2 proposals from yourself and Ali Omar regarding the proposition to go with 3 years. So we will retreat, we will look at those propositions, and when we do the final draft, just as the person who proposed 5 years and you've proposed 3 years, we will weigh what does that mean to us? What are we looking for in this person that probably 5 years or 3 years is more suitable? And when we come up with the final draft regulation, we'll give justification to the decision we have made. But we have received your comment in terms of the experience. So anybody else who has who requests to have the floor, even as we consider some of the comments. I can see we have Tony Malala. Tony Malala is addressing the question of agreed standardization in the names and roles. That that is Matthias Chesoli. Chesoli is the one addressing the issue of standardization in names and roles, as earlier mentioned. As I said, when the regulations come out, it is not an instant prescription. We also have transitional clauses, so that would minimize the pressure on the industry in terms of going back to rework your manuals immediately. But my colleague said the key thing we are looking for is the function other than the name. So the function is the most important other than the name. Tony is talking about it's paramount that the industry is consulted before making some of experience requirements for different roles in safety, quality, baseline maintenance managers. Degree holders are being discouraged from applying their knowledge and are not being accorded consideration. I think, Tony, what we engaged in today is the consultation. We have written a bad draft, so to speak, and we are coming to you as stakeholders, and you're giving us your comments, and we are taking them on board. So when we draft the final regulations or final drafts of regulations, you'll be able to see some of these comments you're making permeate through. We have seen that urge that we consider degree holders as qualifications. Tony is also talking about consider safety manager requirements need to be both from academic, degree, and professional area. So we are seeing much more of that in the degree area. Then again, we have David Makalu arguing for 3 years and not 5 years. So we are getting that on board. Joseph Maina, the authorities considered requiring technical qualification for safety managers or safety officers. Technical qualification being a pilot, AME, FO. One cannot coordinate safety in an industry they have not trained in and do not understand. And I think that is why we have requirements regarding having held or holds a license and the number of years, so that we are sure the person who is getting into these positions has an understanding of the industry. But again, with the comments we are receiving, we'll be able to harmonize that. Murugi is still seeking for us to clarify requirements you discussed in line for staff to in SMS training. I believe ICAO mentioned training, but leaves it open for CAs to set requirements. Then Omar Ali and at Otieno are addressing Regulation 15, Subregulation 3 within the responsibility of safety data protection for both regulator and service provider. The clause on competent authority should be clearly outlined. Is the authority an internal body within the organization or a state body? So my colleague Lois would respond to those questions.
Indeed, these are many questions. Captain Gad, Ali, I've heard the argument for the 3 years, and we will consider that. As we said, we have gotten feedback. Remember, the AMO regulations had put the requirement for 7 years, the AOC regulation at 5 years, and the ATO at 3 years. And this was discussed, and 5 years was settled on as an indicator of who and the professionals that are available in the industry. And as my colleague Lawrence has said, this is collecting your views. We will go back and discuss those again. So that will be clarified. In terms of the requiring technical qualifications for safety managers, there is a for and against. As Joseph Maina puts it, have we considered requiring technical qualifications? So there is an argument for and against in terms of, and I think it was Captain Gad Kamau who mentioned that someone has gone through a degree training and they have the competencies and understand and have the mindset to actually capability to do some of the safety manager roles. But then again, there is that background, and that's why we are talking about the 5 years experience. Now you see where we are coming from. When we talk about you having some experience in your field, and remember, we are not saying experience as a safety manager. Personally, I am here as a SSP coordinator. I have my 12 years experience as an air traffic controller. So I don't expect a safety manager to have had 5 years experience as a safety manager. But in their background, whether it's flying, whether it's an FO, whether it's a maintenance technician, an aerodrome operations person, aircraft manufacturer. So it doesn't mean that you need 5 years experience as a safety manager. And I am concerned when people say 5 years is too much. So we will deliberate that. But requiring technical qualifications, it is an or. As I read earlier, maybe I can read again. For the technically qualified person related to the product or service provided by the organization. That is degree stroke diploma or license. So you could come in with your ATPL, MRML, ATC license with your ratings and have that, and you pass the qualified technical qualification part. So Joseph, I think that is where we are at. We have to consider there are those who have their licenses and there are those who will come in who have done their degrees or diplomas in safety management, so they have that training. when the next question, Murugi talks about SMS training, the training requirements that we discussed are for line and management. Remember, when we oversight your SMS, we look how is your training conducted, and basically what we look at, are you covering the 4 pillars or the 4 components and the 12 elements of SMS? So it is very straightforward, and it leaves it open for the for the CAA to set requirements. Yes, we would set those requirements, but as I said, safety is outcome-based, it's performance-based. Are you training your people to understand all the elements of SMS? Are they being trained how to respond to emergencies? So that is what we look at when we provide oversight. Remember, this is a new element in terms of establishing an SMS in this country of ours. Many people have not fully implemented SMS. So we are still in the implementation phase. Very few companies, we can say, have done 100%. So in that, we allow you to train according to your size and complexity. What works for your organization, as long as you cover all the elements that are required in SMS. Ali, you ask about regulation 15.3, subregulation 3. Maybe I need to check on it. Stand by. As I open that. Okay, so regulation 15, subregulation 3, the authority and service providers shall not make available or use safety data or safety information collected, stored, or analyzed in accordance with regulation 11 or 14 for purposes other than maintaining or improving safety, unless a competent authority determines, in accordance with the 3rd schedule to these regulations, that the principle of exception applies. So basically, this information, safety data, is not should not be used for any other purposes. And we have seen where safety data has been used, maybe in disciplinary proceedings, or sometimes it's also given out maybe to media or published, where you talk about a story, talk about an event or an incident, when it is safety data that you have collected as a service provider, and you have that in your safety systems, that should not be used for any other purposes apart from safety information, and it can only be retrieved by the principle of exemption. I think that is outlined in the 3rd schedule, and the competent authority is already put there. It could be the judicial courts, or by summons. So that is outlined in the 3rd schedule. So I'd ask Ali to check on that. Yes, I can see someone else who talks about, depending on the organizational culture, 5 years is adequate given the task the office holder will carry. That's an interesting. Deborah asks, would you kindly advise the industry on SMS requirements as far as AMO is concerned? The regulations do not address safety issues related to hangar-stroke workshops. How then would an AMO develop SMS manuals within the setup of regulations, even going by guidelines? Deborah, actually that is very well addressed in terms of AMO. You are required, as an AMO, they are required to set up an SMS, and I would just like to advise you that the regulations do not give all the information. It sets the requirements, and there are other documents that we call the technical guidance materials. That's the advisory circulars that are usually published by the CAA that will help you in terms of safety issues related to the hangar workshops, as you said. So that is actually addressed. Yes, Anyango has pointed out that the principles of exception in the third schedule are currently as per the previous scenario where the responsibility was solely on the authority needs to be, Anyango, that has been catered, and I think I presented in the matrix where we are changing. Places where it was only the responsibility of the authority, we have put it as authority and service provider, but we've taken up your comment. In case we left out service provider, it will be added onto the text. So I think that's what I can see, Lawrence, from my questions.
Okay, I think we've kind of discussed that extensively. I can see just a rejoinder from Rugi regarding the issue of ICAO being SMS being designed highly towards flight safety and not towards ground safety workshops. I think probably we need to engage in sensitization engagement on that one to be able to ably explain how the structure of the SMS is designed to suit any operational environment. You only provide information that goes with your operational environment. So in this engagement regarding the regulation development, probably we will work on that more and engage each other in sensitization or in a different stakeholder engagement forum. As you are aware, we are coming almost to, we've overshot the time allocated for this, but I have one question. I have one question from Omar. He would like to make a question, so I'll allow Omar to ask one question. Omar, if you can use a minute or so, you have the platform.
Hello, thank you again for the opportunity. Just a question on the data protection regulation. There's a very thin line between data protection and human resource disciplinary items. You see, as much as we protect the people, I think the protection should be limited to things being taken to the public. But for matters, if let's say you are not competent as an individual and you keep making mistakes, the organization reserves the right to use that information for its own improvement, because some of us are also subjected to KPIs, and part of the KPI is to do a certain job. But if you are not doing a certain job safely and that information comes to light to the organization, of course there is the laws of the land that govern us in terms of human resource. Those apply, but you can't say that this information that the organization has cannot be used for the same. That's why I ask, can data on alcohol test form part of the protected data? If you have a pilot or a manager who is drunk at work and that information comes to light, can that information be used? And if it can't be used, why should it not be used? And it is information that the organization has and sees. Thank you.
Thank you, Omar. I think my colleague Lois would be able to respond to your question with regard to protection of safety data. Lois.
Okay, I think we are back now. Ali, just to get back to your question, when you talk about safety data, remember you're supposed to establish a safety culture and a just culture, which brings in a non-punitive approach. And that non-punitive approach has a rider where unless it is established that the person did the error or the mistake and there was willful violation. So there's a thin line. So you cannot have a just culture and putting in that safety culture, and then you use the same data which people are reporting, their errors and their mistakes, to, for example, conduct disciplinary procedures. So there is an exemption in terms of, there is a rider that as long as there is no willful violation. And I think it also brings to us that we need to highlight more and sensitize people more in terms of the safety culture that is required in organizations. So that is what I can comment about that. So as much as we are protecting data and keeping it confidential, that if there is willful violation, that data is, of course, can be used to provide that punitive function to the person who has the violator per se. And it's the same with the authority. When you provide information in our safety systems, we protect that data and it cannot be used for any enforcement or any proceedings as long as it is we establish that there wasn't any willful violation of the same. So that is it. That Kamlesh, I see your comment. It's safety is ICAO's guiding and most fundamental strategic objective. Hence, all involved should be aware of the safety culture in aviation, and I agree with you. So Ali, yes, unless an authority determines, and it can be determined, as I stated, by an authority that is given the judicial powers to get that information. For example, if there is a commission of inquiry after an accident and they require this safety data, you are obliged as an organization, as an operator, to provide that information to the judicial courts that have asked for this data. So that is it for now. Lawrence, I believe we have Mr. Ali, you'd like to have permission to speak. Maybe if you can type your question. In terms of, we have another comment where could the State Safety Program Office consider putting together engagements on emergency response to operators? This is noted, and those advisory circulars will be out soon. We did talk about the exemption. Data on alcohol tests form part of the protected data. As we talked about, if there's willful violation, you're not supposed to come to report to work drunk, so that is a violation, and it is not protected data. It's not safety data. Okay, so it's the same issue. Mr. Ali, you can comment.
Hi, Lois. Thank you for the opportunity. My concern is, you see, we understand that we have these mechanisms internally that form part of the safety system. However, when you put some limitations or restrictions on the law, you might end up in a scenario where you have willful violation. Then the matter goes to the next second stage and third stage, and a person goes to a court of law and says, you know, you had to report to the authority, and the authority had to determine. It is not you to determine. So it some sort of takes away that right, of course, for an organization to even try and stop a future safety violation. You know, when you see someone who has willingly violated the regulations, the safety standards, and you say, put it to a stop, but because of the limit in the law, that of course puts us in a very difficult situation. I'm not saying that companies should be striving to fire people, but I'm saying there are some people who come to work drunk, knowingly they are coming to work drunk. You've taken them through all the mechanisms, and the persons still repeat the same, and you're forced to part ways. On such a situation, with limitations on the way that law is written, it says unless competent authority, you see, you can't use this information you gather to do anything as an organization, and the information is not limited to what people report. It's limited to the data you collect as an organization from. If you have a pilot who is doing very unsafe operations, and the FDM tells you that, you can't ignore that information and say, I'll still operate with him because the authority has not told me he's unsafe. Anyway, I rest my case. Those are my contributions.
Yes, Ali, I hear you. And I said, and I think I made it clear that where there's willful violation, this does not apply. Where there's willful violation, and it is there in your safety manuals, that there's a process where there's willful violation. And it's the same thing with the authority. Where there's willful violation, we go through the enforcement process, and it's the same in the organizations. Where it stops is where there's normal safety data. Yeah, just an error that happened. There wasn't any willful violation. It was an accident in terms of just a mistake or a lapse. You lost your situational awareness and something happened, and there was an incident or an accident. That is where that is what we're talking about. Where there's willful violation, as I said earlier, the organizations have that disciplinary process that they can follow. But where it's an error, an omission, where it was not willful, that's where we're talking about having a judicial process that says that this is the data that you can only bring in an enforcement where there's that competent authority that talks about that. So we'll have some more sensitization on that. But I hope it is clear that you are allowed to make those disciplinary proceedings as an organization if you realize that there's willful violation. Thank you very much.
Lois, me and you understand that, but that law that is written there, the proposed law, does not talk about willful violation. So, that's my concern. Willful violation is not mentioned in that law. And once this regulation passes, it's law. And law is subject to interpretation. And okay, that's my concern. Me and you are on the same page with everyone else, but once it's law, it's law. It's, we are here because we're looking at the future. These are the fine print. Some of these things can be left out in the guidance, but technical guidance, but on the law, when you put such limitations, someone will go to court and say, the court after 5 years will say pay him. And you'll be put in a scenario where, you have to close out. Let's close it at that. We are running out of time.
Okay, thank you, Omar. Thank you, Omar. I think Lois will conclude her remarks and then we'll move on.
Okay. Ali, we have had you, and that will be considered. And I would just like to thank all of you for participating in this stakeholder forum where we have taken in your views. We have seen can the SSP office come into operators to attend AOC inspections for the renewal of certificates? We have taken in that comment, Madam Wamoshe, and thank you very much. And we shall be giving you the comments and your insights into the proposals later.
Okay, thank you, Lois. I think we are coming to just about 3:15 or thereabout. I think we had a session that follows this one I would like us to proceed next to direct to that session. With regard to the comments that you have given, the dialogue we've had on various issues on safety management regulations, we will be taking care of all the questions you've asked in the questions box and comprehensively responding to them in the matrix we will develop after this stakeholder engagement. So whatever you have given us, we will capture it and then be able to respond to it comprehensively. So allow me to introduce the next set of regulations that we want to look at, the draft civil aviation approved training organization regulations. The approved training organization regulations relate to the regulations put in place to control training within the aviation industry to an extent that of the training that are offered for purposes of licensing or regulated training as they are referred to in other regulations. So to help us appreciate the draft civil aviation approved training organization regulations, we'd like to welcome Pratiksha Patel, who will walk us through the matrix and walk us through the questions that have been the remarks that we have already received, and then we will be dealing with the questions as we go along, just as we've done with the rest of the regulations. So allow her to make her presentation first, address the matrices, and then after that we can have a dialogue. Patel.
Good afternoon, and thank you, Lawrence, for that introduction. Good afternoon, everyone, and welcome to this draft presentation on the Civil Aviation Approved Training Organizations Regulations 2021. Allow me to just share the presentation as I take you through the matrix. Okay, so as we're going to go to the matrix of this Approved Training Organization regulations, I'll just be taking you through the changes that have been taken place in the regulations. Starting with regulation number 2, where it talks about the definitions. We've added 4 new definitions. We've added the accountable executive, and the reason of changing that from the accountable manager is just to align it to the Doc 9841. The new definitions that were added were the safety manager and the maintenance manager, and a definition of the finding was also added in order to align to the Doc 9841 for the approved training organizations. In Regulation 7, what changed was it was a typo error. We had a repetition of the word approved training organization, so that repeated word was deleted just to align and rephrase it. Coming down to Regulation 7, Subregulation 5, an addition was made on Subregulation MIC just to include on inspections of approved training organizations. We have included a section on the safety management system. This is in order to align it with the other regulations like safety management systems together with the doc and the Annex 1. Coming down to Regulation 13, Subregulation 3 was the regulation was basically amended for clarification purposes, and also align it with the Doc 9841 section 20.1. On the same regulation 13, subregulation 5, the regulation was rephrased for clarification purposes. On regulation 14, subregulation 1, a few changes were made in terms of addition of all the key management personnel. In the initial regulation, not all management personnel were catered for. Therefore, just to align the regulation to meet the requirements of the Doc 9841, the other key management personnel like the head of training, CFI, CGI, maintenance, and the head of safety were added. Subregulation 17, there was a deletion of some of the irrelevant courses that do not have approved licenses, something like the flight navigation license, the refresher courses, the EDO, human factors. They are not approved courses, therefore they were deleted and amended just for clarification purposes as well. On Regulation 18, subregulation 1, there was a rephrase from the word must to the word shall, and was amended to include all key positions and to also align it with the Doc 9841. And an addition was made for two major positions. That's a maintenance manager and head of safety as applicable. On Regulation 18, a new subregulation was added, that's Subregulation 6, and it was also rephrased and reworded just to enhance safety and also to align it with the DOC 9841. On Regulation 19, Subregulation 2, it was also amended just to align it with the ICAO DOC 9841, Section 3.8.1 and 6.1. Regulation 21, Subregulation 1, Bravo. The word qualified was deleted since Kenya has a state we do not qualify simulators, but we only approve the simulators. On Regulation 22, Subregulation 1, the word helicopter was incorrect and it was just rephrased, and the word flight was added to cater for both helicopter and aeroplane flight training. In Regulation 23, a new regulation was added, a new subregulation, that's Subregulation 5 was added in order to align it with ICAO DOC 9841. Going to the next regulation, Regulation 28, Subregulation 1, Foxtrot, the word ICAO was referenced in our regulations, therefore it was deleted and amended for clarity purposes. In Regulation 43, a new subregulation was added, that's Subregulation number 6, where it was catered for all the administrative staff that shall be employed by an approved training organizations, and this was done in order to align it with DOC 9841, Section 8.3, Annex 1, 7.3, and Appendix 2 of the same annex. In Regulation 43, a new subregulation 7 was added in order to align the regulations to read the same as DOC 9841, Section 8.2. Going down to the schedules, we will start with the third schedules where most of the amendments were done. Starting with the third schedule, Part A, the general section, where there's a qualifications of the quality manager, which was quoted as the head of quality, basically. So we've just said as head of quality. And the sub-regulation alpha was reworded for clarification purposes. In the same third schedule, Part B, under the flight crew training, Subregulation 2, Chief Flight Instructor, Part D, the qualifications of the Chief Flight Instructor was amended just to include the experience that shall be required by the Chief Flight Instructor. On the same third schedule, Part B, under the flight crew training, Chief Ground Instructor, Subregulation Bravo and Subregulation Echo was amended for clarifications purposes, and also it was amended to include the amount of experience required by the chief. The third schedule, Part B, under the flight crew training for ground instructors, it was reworded from the word license to authorization for clarification purposes, and also to align it with the document. The third schedule, Part B, under the same flight crew training, 2 new position qualifications were added. That's the maintenance manager qualification was added, and the head of safety qualification was added. You can as well call it a safety manager. We do realize that. On the same third schedule, Part C, for the aircraft maintenance engineering, the word extensive training was quantified to have 3 years experience. So it was amended for clarity purposes. Third schedule, Part C, aircraft maintenance engineers training, the requirements of a chief aircraft maintenance engineering instructor. What was amended there was the qualifications in terms of to include the experience required for you to be a chief instructor in any AML ATO. Part D, air traffic control training. In that regulation, Part E also was amended just to, the word extensive was removed and was quantified into a number of years of experience, which was 3 years. Going to part D, air traffic control training. The air traffic control chief instructor shall, subregulation A was amended to include the amount of years of experience one shall require in order to hold that position. On the same schedule, the head of training and for the flight operations officers training, that's part ECHO, subregulation Bravo was the word extensive was removed and replaced with 3 years experience in training and teaching and managerial capability. Third schedule, part E, flight operations officers training on the chief instructor qualifications. The word or was deleted between subregulation Alpha and Bravo. And another amendment that took place in the same qualification was the word experience was deleted and quantified into 3 years of experience of training and training requirements for an FO. So that brings me to the end of the matrix of the amendments that have taken place in the approved training organization regulations. And I think we shall look at your comments now to see if you have anyone has a comment, we are ready to address on the same. Okay. Since no one has active questions on the chat box, we shall look at some of the comments that we received on our email early on during the week, and we shall address some of them. I don't think so. So one of the few comments that we received on emails was on regulation 2, and they would like to retain the word maintenance liaison officer instead of the word maintenance manager. Well, the reason of us aligning and changing it to maintenance manager is just to align it with the ICAO Doc 9841. The next comment we have is on regulation 13, where we say the comment we have is retain the word certain training activities. Okay, we shall look into that comment with the ICAO doc and we shall harmonize and take care into a final draft of regulations. Another comment we have is on regulation 13, subregulation 5, where the comment states that an approved training organization and satellite approved training organization shall execute a written agreement in the case that a satellite ATO is a different entity or outline procedures in the case that a satellite ATO is the same entity, defining the safety and quality related services to be provided. The satellite approved training organization safety related activities relevant to the agreement or procedures should be included in the approved training organization's quality assurance program. Basically, the word from execute a written agreement and it was changed to shall outline procedures is just to align it with our document, section 20.2. So that's the reason of rephrasing that regulation. Okay, another comment we do have is on subregulation 23, on regulation 23, subregulation 5. And the comment we have is it's a requirement which is out of hand for most ATOs, as it is a KA that provides facilities for majority of the ATOs. And the comment here is that the subregulation should be deleted. Okay, we've taken into your comments for this one. Definitely we will sit down as a team and see what it can be aligned with the doc and get back to on that one. Okay, and I think another comment we have is on the third schedule, part B, on the flight crew training on the requirements of the chief flight instructor, where the comment is to delete the golf, which says have at least 3 years experience in flight instruction with a minimum of 500 hours total time and a minimum of 200 hours instructional time. and you like it to be replaced with the word insert have full instructor's rating. Okay, so we will definitely take care into that account. However, this is just to notice that the regulation just spells out for the experience. Therefore, an instructor is an instructor. So we're just giving out the experience you require in order to be a chief flight instructor. Okay. Another comment we have is on the third schedule, part B, flight crew training. To change the maintenance manager to read maintenance liaison officer. As I just mentioned earlier, that this was done just to align to the requirements of the ICAO Doc 9841, as it spells out is that maintenance manager. And also on the same, I have a comment on the qualifications of a maintenance manager to have Alpha and Echo, and to delete the rest. However, this can be done in consultation with the airworthiness department and airworthiness inspectors. So definitely we'll look into this comment and we shall get back on the final draft of regulations. Coming down to the comment on the safety manager, I think my colleague early on, Lois Mwangi, when she was presenting the SMS regulations, has catered this and has answered most of the questions regarding that. So that brings us almost to the end of the comments I've had. I think I'll hand over to my colleague, Lawrence.
Okay, thank you, Prat. We have those are the comments that were received in the region in terms of written submissions. We have been able to address the matrix, what was gone into the amendments. We've also been able to address what was received earlier in terms of written submissions. I've seen a question on in the Ask a Question dialog box, which the first one is from Douglas Karoki, and I think it has been addressed. That Regulation 17 addresses flight crew training. He was talking about aircraft maintenance engineers training on Regulation 17 of the draft. That has been addressed. Gidhae Mwaniki is asking about question on maintenance manager. I'm not very clear on what the detail of that means, whether he wants to ask a question on maintenance manager. So Gidhae Mwaniki probably will allow you an opportunity to okay, question on qualification of maintenance manager. Question, okay, I think it was retyped up there. So my colleagues, Patel and a colleague, will consider that and give you a response. I'm seeing more of a comment, or I don't know whether it's a question I would like to respond to here from Gad Kamau in terms of inspector currency and regulations that are duly overburdened. I think the regulation making process is a consultative process. So if there are provisions that we or have been made in the regulations that probably you find would be a challenge to comply with or would be a challenge to implement, then this is the forum in which we are able to align those issues and address any of the challenges. So I'm seeing another question from Grace asking that you confirm, please confirm that you addressed the comments from AATO in its totality. Grace, what we would tell you is we've responded to what we have been able to respond here. And at the same time, we would be producing a matrix of how we have considered all the comments we have received. So at that point, you'll be able to see we have addressed everything that we have been given in terms of question. Diana Ndungu is asking on how can we download the past sessions. I think we'll address that before we close this session on how you can download the past sessions. That is the sessions we've had earlier on in the morning and the earlier session on safety management. Gad Kamau is talking about the GAV6 CRM do not require ATO license to conduct courses. I would allow my colleagues also to respond to that. So my colleagues have two questions to respond to in terms of dangerous goods, aviation security, CRM, requiring ATO license to conduct those courses. and the qualification of a maintenance manager from Gidaya Moniki. So
thank you, Lawrence. I'll start with Gard Kamau's question on the DG AFSEC CRM do not require an ATO license to conduct cases. That's true. We do not give ATO certificates for any other courses that are not approved by Annex 1. However, we do recognize them and we do have our procedures outlined, and the same advisory circulars and all can be found on our website. So if you like to have a look at them. Coming down to the next question on the qualifications of maintenance manager by Gitai. Here, I would just like to say this is done in conjunction with our airworthiness department, and I would not be able to speak on behalf of them at the moment. So definitely we'll look into this comment that has been presented to us and on the final draft regulations, which will take into consideration on the same. So maybe Lawrence, you like to, because I cannot see any further questions on the chat box.
yes, we do not have any further questions. I cannot see any other question. And what I would do is to request our technical team probably to come in and explain to our participants how they can be able to download the comments of, or rather the recordings of the earlier sessions. Okay, so I'm being told by the technical team that all recordings of all sessions will be uploaded on the KCAA website. So we'll create a link there under the 2021 draft regulations, where you can be able to access all recordings of all sessions of this stakeholder engagement. And if you have any other issues, you can be able to reach us on the email address that was provided for this purpose, that is kcas2021@kcaa.or.ke. So any other questions? I think we'll allow for a minute or two for any other question that you might have. The last of the questions that appear in my chat box are from Gad Kamau, which I think has been responded to. Thank you. So in the event that we have no further questions, we would like to bring this to an end for today. It has been a long day. We appreciate the challenges that come with the new approach to this, what the challenges that come with the new approach that we are using for stakeholder engagement. However, we want to maximize the ability to get to you. And so as we interact here, we also remain open in terms of our email address, the one that we have created for these purposes, for written submissions. So today we've managed to go through the personnel licensing regulation in the morning. Then we went through the Air Operator Certificate Administration regulations. And closely related to that, we also dealt with issues, airworthiness in terms of personnel licensing and AOC. We then dealt with safety management regulations, and we've dealt with ATO regulations. So in total, we've gone through 4 sets of regulations today. Our in-tray has 30 sets of regulations. So over the next 4 days, we will be looking at another 26 sets of regulations. And we would just like to encourage that even if you have any written comment on the 4 sets that we have discussed today, either something that has popped up as a result of the discussion we've had, you are requested to reach us through the email address that we've provided so that we can be able to incorporate that into the considerations we are making for the regulations. We will be looking to developing final draft regulations with your comments incorporated and then published again to you for your review before as we proceed to the publication of the regulations. So I would like to thank all of you for your participation and just highlight to you what we look forward to in handling tomorrow. Tomorrow, our program would start at exactly 8:15, and we will be looking at the draft air operation of aircraft, commercial air transport regulations, draft instrument and equipment regulations, draft operation of aircraft, general aviation regulation, draft helicopter operation regulation, and then the draft licensing of air services regulations. So tomorrow we have those regulations to look at. Kindly, if you are able to access the regulations on our website and the matrices, so that we can simplify the interactions and be able to address the points straightforward, we would much appreciate that, as it would make the burden or the job much easier. Otherwise, without further ado, thank you very much for those who joined us today. We look forward to meeting you again tomorrow and for the rest of this week as we discuss the draft Civil Aviation Regulations 2021. With that, we'd like to call an end to this session. Thank you very much and enjoy your evening.